As a constitutional law attorney, former senior legal advisor and personal counsel to President Donald J. Trump, Jenna Ellis believes in the rule of law and the importance of integrity in our elections. And she's ready to tackle the big cultural and legal issues facing America. This is the Jenna Ellis Show. Here is your host, Jenna Ellis.
Project Veritas has now found out and discovered that back a year and a half ago, there were at least 9 separate warrants that the government gave absolutely no articulable basis for asking to have these warrants and this search of property that was actually in the cloud of Microsoft, Apple, and Google for Project Veritas's documents that are stored in the cloud. They just found this out from Microsoft, and they released this video yesterday. Watch this.
A week after Microsoft's brave support of the First Amendment, Apple and Google have come forward to disclose that between November 24, 2020 and March 15, 2021, the Department of Justice issued 9 secret subpoenas and warrants to them.
In fact, just last month we learned that the Biden Justice Department targeted Project Veritas, having its emails seized on Microsoft servers.
And to make matters worse, the government can send gag orders with these subpoenas that prevent service providers from telling the targets that their information has been given over to the government.
The DOJ used secrecy orders against Project Veritas. The DOJ then went behind the judge's back to obtain an extension on 2 sealed non-disclosure orders.
We recently reported the Department of Justice secretly seized emails from journalists' Microsoft accounts and hid that from a federal judge. Well, it didn't stop there. The services we all use every day have also been compromised. New documents reveal professional and private accounts from Apple and Google were secretly obtained as well. This comes on the heels of bipartisan support for legislation protecting journalists from gross government overreach by the Department of Justice. This is not just about Project Veritas. There are thousands of these secret orders issued every year. Ours are just a fraction of that.
Members of this committee heard testimony that the DOJ is not, in fact, using these NDOs in limited circumstances, but rather issuing thousands of these secrecy orders every year.
These orders are not just limited to journalists. Everyday American citizens are also being spied on by these secret orders, signed without so much as a hearing. Not only were they spying on our journalists' accounts, the Department of Justice was also spying on our security detail. This is a letter sent from the Department of Justice to Google in California, signed by the United States Attorney in the Southern District of New York. They compelled Google not disclose they were obtaining the correspondence of our security details Google Gmail account. The Department of Justice wasn't just targeting our journalists, they were going after those tasked with protecting the journalists' lives. Think about what is in your Apple and Google Gmail accounts. These are not just emails. These are your text messages. These are your private photographs of you and your children, your iCloud accounts, your location data, everything. And in the case of journalists, this also includes the information of our sources.
In a free country, we need to make sure that the government cannot unmask journalist sources without good cause. This bill provides those protections, and it is time we get this legislation signed into law.
Those in favor respond by saying aye. Aye. Opposed, no. The ayes obviously have it. The bill is ordered reported favorably to the House.
Case in point, we've just learned from the court's filter team that messages from our confidential sources that have nothing to do with the Ashley Biden diary were seized and may have been viewed by the Department of Justice. That can have an incredible chilling effect on sources' ability to trust they can come to journalists without facing retaliation from their own government. We filed yet another motion in federal court demanding the Department of Justice return our property immediately and stop spying on us and stop spying on sources that have nothing to do even with the diary. It's time the Department of Justice answered for their actions. And we now know the Department of Justice shopped these secret orders around to 9 different magistrate judges, apparently in their efforts to keep the breadth of their overreach hidden. As our lawyers write, 1. The seizures violated the express provisions of the Privacy Protection Act. 2. The seizures violated the First Amendment. 3. the seizures violated the common law reporter's privilege, and 4, the seizures violated the Fourth Amendment's prohibition against unreasonable searches and seizures. The government knows the truth. Project Veritas engaged in journalism protected by the First Amendment. Whether these prosecutors have operated without appropriate supervision or the highest levels of the administration's Department of Justice are complicit in this investigation into Ashley Biden's abandoned diary. As the Reporters Committee has requested of federal judge Annalisa Torres, it is time for the Department of Justice's affidavits by which they obtained these unjustified subpoenas be unsealed. And just this week, Judge Torres has ordered the government to respond to our motion seeking return of our property. The judge ordered the government must answer by May 6th. And it is time for the court to curb the government's lawless behavior.
So joining me now to discuss is my good friend and chief counsel for Project Veritas, Jered Ede. And Jered, this has so many implications for everybody, not just journalists especially, but even for private people who are thinking, are Google and Apple just giving my information over to the government? I mean, what's going on?
Yeah, this is really, frankly, shocking revelations to hear that our own government has been spying on journalists, and not just journalists, but even the journalist security guards, to get their Apple and Google account information. I mean, think about what's on, someone's Apple account, the backups on their iPhones. It's everything. I mean, text messages, photographs, location data. Where do you live? Where was the last, what's your favorite coffee shop? Everything down to that. And when you think about it from the standpoint of journalists, that includes even, for example, information from confidential sources, which virtually every court that has dealt with the matter has said the government has no right to know.
Absolutely. And this is really disturbing for journalism as a First Amendment protected fundamental right to make sure that you can cover the government fairly, protect sources. And you're right, every court generally has protected that right, especially to be free from this type of interference. But with the rise of big tech and doing everything with our smartphones, I mean, this isn't the gumshoe era of investigative journalism where, you meet people in secret all the time and you can, hide more easily, I guess, a lot of the information. I mean, these are things that are in repositories that are controlled by big tech. And so you now, Project Veritas, have filed a motion with this new revelation coming out, because this actually happened for people who just saw the video. I mean, I want to reiterate, this happened, and these, 9 warrants were between November 2020 and March of 2021. So you're just now, a year and a half later, finding out about this. So what are you doing legally to try to stop this threat?
Absolutely. Well, we've filed kind of a whole host of motions over the last couple of weeks because this is really, truly an egregious violation of our rights in a variety of different ways. Most recently, we filed what's called a Rule 41G motion for return of property. And if granted, effectively what that means is the government would be forced to give all of the documents and give all of our property back to us, which we think is frankly the bare minimum of what the court should do in this circumstance. If you think about the fact that, for example, in December, right after the raids happened, December of last year, we had asked for and were granted a special master that effectively the U.S. District Court had said the government should have adult supervision in viewing our documents so that we can protect our First Amendment, our journalistic privileges. And then we find out that not only, number one, have they already had all those documents and potentially already reviewed all those documents, but they haven't disclosed that to the court, arguably did not properly disclose it to the special master, have in fact therefore been trampling over our rights this whole time, but then perhaps most egregiously, even after the appointment of a special master, gone back into court to a different judge, mind you, and asked for an extension of these gag orders to prevent Microsoft from even telling us about these things. This is how it all began, is Microsoft said, we won't stand for that. And the government, when they faced the opposition, when they realized, man, we've lost Microsoft, they backed down. And Microsoft came to us within hours, and we started discovering all of this. And then Apple and Google followed suit and came forward. And I think, what Microsoft's point here was really, truly to the heart of this matter, which is, we don't keep a filing cabinet right next to us in a physical office anymore, right? Our digital society is such that the filing cabinet is now in the cloud. And the government is now taking advantage of that to effectively say we get to raid that filing cabinet and take everything that's within it without even so much as telling you that your items are being taken. And Microsoft's point is that's problematic when you consider the fact that when Project Veritas knew that its things were being taken by virtue of the raids, not only did we take steps to protect our privileges, but we were successful. And the court agreed that our privileges deserve protection. Jenna, keep in mind that as a result of the Microsoft, documents that they obtained, our most recent 41G motion lays out the federal government obtained over 200,000 emails of our journalists documenting stories going all the way back to January 1, 2020. By the way, 8 months before we even learned that this diary existed. And they've seen all of this information. Now, meanwhile, the special master has reviewed everything that was seized during the 3 raids that happened in November, and thus far has turned over less than 300 documents to the filter team saying these might be relevant.
Wow. And for people who are, so many questions, but for people who are kind of still coming up to speed and wrapping their mind around this, obviously this has to do with this pretext of Ashley Biden's diary, but what was the pretense even before that to go and shop around all of these warrants? And according to your video, it was, 7 or 8 different judges. And so of course they were forum shopping and almost trying to diversify so it didn't look like a coordinated effort. This is just disgusting what they were trying to do here, but where did this even start? What is their goal?
Well, and that's something that I think every American, and frankly Project Veritas as well, but every American deserves to know is what was the government's basis to go into court and seek these secret orders? And no one knows. And that's problematic. Even the Reporters Committee for Freedom of the Press has come forward and said, the press, the public deserves to know these answers. And the government's response was, no, you don't get this. You have got no obligation. We've got no obligation to tell you the basis for any of this happening whatsoever. We can trample on rights without ever telling you what it was that actually went in this. The ACLU, even, of all people, has come to Project Veritas' aid and said, we don't agree with what Project Veritas does, but gosh, what the federal government is doing here is such an egregious violation of our basic fundamental First Amendment rights that, according to the ACLU's statement, the government should cease review of all documents immediately. That's groundbreaking, fundamental. You've lost the ACLU. That's how bad the SDNY's actions here were.
Wow. And this just, it smacks of government elitism to think that somehow the government doesn't have the obligation to tell its citizens when they are going to get these warrants. Just like what happened with the FISA courts, and why everyone was so frustrated with the whole Spygate issues and everything else that happened to President Trump. That always seems to happen to conservatives. And obviously, Project Veritas is independent investigative journalism that simply stands for the truth. That's literally what Veritas means. But I think it's so interesting that everyone tries to paint you guys as some kind of majorly conservative outlet where you're seeking truth, period. But because you're seeking truth and because generally that truth is not liked by the deep state that happens to be more leftist, then you're painted and categorized as activists. Even in the AP story today, conservative activist organization, I'm thinking, no, they're journalists and that matters. And that to me is just so egregious of the very premise that the government has absolutely no right or no authority to go in without telling you and articulating a sufficient legal basis. That's the entire premise of anything that the government ever does in law, is that they have to articulate whether it's a probable cause standard or whatever the standard in the law is. And when you're talking about these cloud repositories, this gets into Fourth Amendment territory, I think, as well, because when you're talking about an unreasonable search and seizure. There's always a standard that the government has to show first so that you as citizens can be secure in your documents and effects. And it shouldn't matter whether your filing cabinet is located in your private physical office under lock and key, or whether it's with a company like Microsoft that does have access that then they can go to that third party. They still have an obligation to make sure that your documents are secure in the cloud.
Correct. And, we talk about this in our motion for return of property that, the United States has effectively gotten away from what are called general warrants, the idea that the government can just go and say, well, your crime's been committed, so therefore we get all of your stuff. And let's just take a look at it and see what's in there. These things have to be reasonably particularized. In the law, we call that probable cause. Mm-hmm. And one has to wonder here, what probable cause exists for the government to take 8 months worth of journalists' emails that exist before we even know the diary exists, before we're ever contacted by our tipsters in any way, shape, or form. If the idea is here that, well, gee, Your Honor, Project Veritas's emails might have evidence of a crime related to the Ashley Biden diary. That evidence doesn't exist in any way, shape, or form. First off, it doesn't exist, period. But second off, does not exist before we learn about the diary. There's absolutely no probable cause for that. And effectively what the government has done here is try to reinstitute an ancient, old English version of general warrants that the United States has long ago said, this should not happen. It's a basic violation of our Fourth Amendment rights. And
this was the entire reason that the Bill of Rights was created, to make sure that just in case the government wasn't clear on what limited powers it has, we're going to now reiterate the principles and the rights that are most often abridged and violated by the government and say, sorry, you can't. I mean, this is very, very basic, fundamental concepts of American jurisprudence that the government seems to be just willy-nilly violating here. And what do you anticipate in terms of the judge that you have? Because unfortunately, sometimes this comes down to whether the judges can set aside their political bias, like apparently the ACLU rightly has, and says, listen, we may not agree with Project Veritas. They may not support what you're doing. They should, because you're just journalists. But they at least understand and recognize that the precedent that's being set here could very well implicate them. And it's surprising to me that anyone would not support this, and any judge would think that this is okay, regardless of whether or not they happen to like Project Veritas or not.
Yeah. Well, what the interesting thing about this battle is it really truly is a bipartisan issue. It's not political in nature. The U.S. Supreme Court effectively addressed this very issue in the Bartnicki case in 2001. And, people are always surprised because, Project Veritas, a lot of our existence is built upon the back of Bartnicki, right? And so people are always a little bit shocked when I inform them, hey, by the way, this was a U.S. Supreme Court precedent that was agreed to by the conservative justices of Ruth Bader Ginsburg and Justice Breyer, amongst others. And
sometimes they get things right. It's a miracle, but sometimes they do. Sometimes it's so fundamental. Even they can't, we'll see if Ketanji Brown Jackson can agree on that, because being a woman is kind of fundamental too, but.
Well, and hopefully, although she may not be a biologist, hopefully she's a constitutional law scholar who's at least read this case. I think anybody that reads this case and reads the progeny from of DNC Federation, of Jean versus State of Massachusetts, these cases lay it out very fundamental that what we did is traditional news gathering that is protected by the very basic fundamental laws of this country. And I think it's very telling that you have the U.S. government effectively saying to an Obama-appointed Article 3 judge, in this case, Annalisa Torres, hey, don't look at those cases. Those are irrelevant. The U.S. Supreme Court case law that's directly on point here, it's irrelevant. Don't look at that.
Wow.
And Judge Annalisa Torres has said, no, we are going to take steps to protect journalistic privileges here. I think the government has overplayed their hand, and they're going to be in for a rude awakening.
Good. Well, so the next steps, the government has an opportunity to respond. Is it by next Friday, or what's the timeline here?
Yeah, the government has been ordered to respond by May 6th. So time's ticking, and we're going to see how they respond. I have a feeling that it's going to be yet more of the, oh, well, Project Veritas are not journalists, the same method that they attempted to play when we asked for a special master, and they again got shot down on that very issue. It's interesting when people say, oh, Project Veritas are not journalists, and they make that argument a lot. You're right about this conservative activist, or, what are we? And they always ignore the fact that the sources they use to just justify saying, well, you're an activist, are from places such as, for example, the FBI's, the government's motion, cited a student newspaper blog from a university. Very reliable source. Brian Stelter would be proud.
Yeah. That's just insane. And again, those types of maneuvering and perverting really the definition of freedom of the press and what press actually means in the context of the Constitution, in the context of protected rights. This shouldn't be groundbreaking kind of stuff, but I think it's so incredibly important what you're doing, how you're fighting to make sure that we have these freedoms that are protected for the next generation, and especially when we look at how really the press and the idea of what it means to be a journalist is evolving just tech-wise, and it's evolving in terms of non-traditional platforms, and it's evolving in terms of what does publishing mean. And so these are questions that definitely deserve to be answered in a logical and constitutional way that makes sense and that actually protects everyone's rights. And so not only is the substance of what Project Veritas is doing incredibly important to just get the truth out there, but these legal battles, from this battle to your New York Times lawsuit and defamation, and looking at the New York Times versus Sullivan precedent from the Supreme Court that I think you and I agree needs to be recontemplated and reconstituted. I mean, these are all things that are at the core of the jurisprudence that comes from the Supreme Court and how we operate and function with free speech, freedom of the press, security. Right. In our papers and effects. I mean, all of these things I think are going to shape the next generation. So you guys are standing up firmly, and I fully support and applaud that. And I'm so grateful to have you on, Jered, because these are battles that absolutely need to be fought. And I wish you really great success with this, because it's absolutely something that we need to get right in order to move forward in America.
Thank you very much for having us on, Jenna.
Yeah, thanks so much.